We start with the stunning not guilty verdict of Casey Anthony. Susan Filan, a former prosecutor and criminal defense attorney. Thank you for joining us, Susan. It's great to have you back, but we always have you back at the strangest moments. In this jury trial, you know, we all watched the O.J. case, and everybody in America seemed to have an opinion about whether he's guilty or not, and maybe that was resolved in a different way out in Vegas months and years later. But this case is so fresh in our minds and hearts. People have watched the face and attitude of Casey Anthony now for weeks on this network and elsewhere. Looking at the picture now, and we looked at what happened today, the incredible emotion of this young woman. Were you surprised as an expert by the not guilty verdict on all the capital counts?
I was shocked and I was stunned, and I stared at my television set in utter disbelief. But I have to remember that my perception of this case is vastly different from these jurors and from members of the public at large. People fall into three categories generally, Chris. She did it, let her fry. I don't know what happened. I'm so confused. And there's doubt all over the place. And it was an accident. So people actually believe what the defense came up with, or they were just so confused and they had reasonable doubt. But as an expert, I thought the case was proven, and I was shocked and stunned by this verdict, Chris.
My father, who sat in court for 30 years as the senior court stenographer, senior reporter in Philadelphia, told me once, if you're innocent, have a judge decide the case. The judge will be rational. He will make or she will make a decision that makes some kind of sense. If you're guilty, go with a jury. You can never predict a jury. You just can't predict them. Is that your belief, or do you continue to hold faith that your own judgment outside the court will most of the time match the judgment of the people in the jury panel?
No, and my judgment doesn't matter. It's what the jurors
Well,
hear.
it does to us right now. Aren't you surprised that the fact that juries have once again shown us that they make decisions in that room that we're not really party to?
Well, here's what it shows. It shows they were clearly sequestered. There was no infiltration of that jury, or else they would have known. Not only was the world watching, but most of the world had already convicted Casey Anthony. The second thing it shows is they really decided on the evidence, or lack thereof, that was presented to them in that courtroom, and they were unanimous. I mean, you'd think perhaps, along with your dad's theory, there'd be a hung jury. But nope, that was a unanimous, quick, speedy verdict. And it sounds to me like they had made up their minds a long time ago that whatever the state was selling, they weren't buying it.
Well, let me suggest a possible logical explanation before we hear from the juries in the days and weeks ahead, when one or two will start to talk, I assume. It seems to me that we saw on television, we learned that a young girl, a baby, really was killed. We know there was all kinds of horror about that, how it wasn't explained and wasn't even reported or anything for weeks and weeks and weeks, and nobody seemed to take responsibility, especially the mother. We also saw the attitude of this young woman in court, which I think we all made judgments about the attitude. She's angry. She seemed to be antisocial. Who knows what it was, but it was something we were looking at. But there was this giant hole of information between that woman's face, we're looking at again here now, and the tragedy. And we could never find ourselves in our minds going step by step to how it happened. Do you think that's what the jury found itself, and didn't buy this alternative theory that the father somehow did something, but just couldn't bring itself step by step to the commission of this horror?
That's one theory, Chris, that there was reasonable doubt. The state did not have a cause of death. They didn't actually even have proof, actual proof of murder. And if there was a murder, which wasn't exactly proven, it was a leap to link Casey to it, although there was circumstantial evidence. Then the defense went with that fantasy forensics, and they had the war of the experts. It's possible the jury just said, you know what, I don't know who to believe, so I'm going to throw it all out. Or they actually bought the defense's theory of accident, and that this child died accidentally. There was no murder, which is perhaps why they didn't go for one of the lesser included. It wasn't that they didn't think she did premeditated murder. They didn't think this child was murdered at all, Chris.
Just to finish out your thought there, watching the case, do you think in any way they bought the real defense case, that somehow the father, the grandfather in this case, somehow came along and made it look like a crime, even though it was an accident?
That's a little bit harder for me, because I did think the prosecution was good when they said, who makes an accident look like murder? And I did think they were also effective when they said Casey Anthony points the finger at everybody but herself, when she's the only proven liar in this case. But it's really hard to tell. It's either they thought it was an accident, or they just weren't buying what the state was selling. It just wasn't good enough for them to convict. So it was either reasonable doubt or it was accident.
Okay, let's watch the action. Here is that stunning moment everybody's going to remember, at least for a while. Let's listen as the not guilty verdict was read.
As to the charge of first-degree murder, verdict as to count 1, we, the jury, find the defendant not guilty. As to the charge of aggravated child abuse, verdict as to count 2, we, the jury, find the defendant not guilty. As to the charge of aggravated manslaughter of a child, verdict as to count 3, we, the jury, find the defendant not guilty.
Let's bring in NBC's chief legal analyst, Savannah Guthrie. Savannah, so good to have you, because I know you so well, and I know how well you understand these things as an attorney and as a correspondent at the big level. Here we are, one of those cases that actually has fascinated a lot of people, including me. What did you make? Were you, can you even say as a straight reporter that you were stunned? I don't know what your parameters are these days.
Yeah, you know, I have to say I was surprised, and the reason I was surprised is how quickly the jurors came back with this verdict, and the fact that it was just a wholesale rejection of the prosecution's case. I mean, the jurors had an array of charges to consider, everything from the top charge of first-degree death penalty eligible murder all the way down to just a straight charge of child abuse. And even though anyone watching this case could see the problems of proof that the prosecutors were dealt, the fact that we don't know when Kaylee died, we don't know exactly how Kaylee died, although prosecutors had theories that were consistent with the evidence, but the evidence wasn't dispositive of those theories. At the end of the day, I thought the jurors might get back there in the jury room and say, you know what? Given her behavior, not reporting the child missing for 31 days, that stench of death emanating out of the trunk of the car, which multiple witnesses agreed to, she's got something to do with this, and we may not know what it is, but we can't let her walk free. I thought the jurors might do something like that. I should say what they did do, if they really didn't think prosecutors had proven this case beyond a reasonable doubt, what they did do was the right thing. They looked at the law. They obviously looked at those jury instructions and determined that the elements of these charges had not been met. But I think a lot of people were very stunned.
Well, do you think one of the things missing is, and we've been looking just now as you've spoken with these nice pictures of mother and child playing to each other very playfully and delightedly to the enjoyment of both. We don't have the case you have in spouse abuse case where some guy who's been threatening his wife for months and terrorizing her and being seen yelling at her in the streets and even hitting her finally kills her. There's no preliminary event that anybody's pointed to of abuse of this child. Isn't that, well, that would seem to be, as a juror, wait a minute, I've never seen had anybody say she hit her daughter, yelled at her daughter, abused her in any way.
I think you put your finger on it. I mean, I've always thought, and I think I've said it a few times, that the motive was always the weakest part of the prosecution case.
Yes.
Now, the prosecutors don't have to prove motive. Motive is not an element of the crime. They would not have seen motive on the jury sheet. But as a practical matter, jurors want to know why someone would behave a certain way. Prosecutors like to put on evidence of motive to try to explain why someone does the things they do. And in this case, prosecutors did put on evidence of motive. They said, here's a young mother, somebody who was a parent too soon, who wanted to go out and party and live the good life. The problem is, as you point out, it wasn't entirely consistent with the evidence. Yes, there was evidence that she was carefree and wanted to go out and have a good time. On the other hand, there were a lot of her contemporaries, friends, who came in and said, oh, we all knew about Kaylee. Oh, we all asked for Kaylee. There weren't any boyfriends who said, oh, I didn't know she had a daughter. She had a mother and a father, the grandparents of Kaylee, who doted on this child, who loved to take care of her and play with her. So presumably, Casey Anthony could have, you know, dumped the child on her parents any time she wanted to, if she wanted to go out at night. So there was always something about the motive that the prosecutors offered that didn't quite add up to me, although I understand why they argued that as the motive, because to some extent it was consistent with the facts they had.
Susan, I want to get back to you on that question. Do you think the absence of any evidence of abuse was a problem for the jury to condemn her?
You know, it's hard to say, Chris. I see what you're saying. There's a leap between these videos and what was presented at court. But when she did the computer searches of chloroform, and the allegation was that she chloroformed her child, to me, that's aggravated child abuse. So even if it was that one instance during the time of the commission of the felony to get to first-degree murder, I thought the prosecution did prove child abuse. But again, I wasn't on that jury, and I didn't have the difficulty making the leap from those videos to the child, because to me the circumstantial evidence was strong. And if you step back, what other logical conclusion could you come to by the way the child, as Savannah points out, to the stench of death in the trunk, the mitochondrial DNA of the hair, the post-mortem root banding, the way she was disposed of in the swamp, all the things that belonged to her at the time she was found that Casey was the only person that had access to. If you add it all up and you stand back and, as the prosecution said, you look at the forest and you don't get lost in the trees, who else did it? Now it's this mystery up there with John Benet Ramsey. What did happen to Kaylee? Who did kill her?
Well,
was she murdered?
Susan, here's one of the Casey's defense attorneys, Cheney Mason, following the verdict. Here he is taking a whack at the media. Here he is.
This is a lesson to those of you who have indulged in media assassination for 3 years with bias and prejudice and incompetent talking heads saying what would be and how to be. I'm disgusted by some of the lawyers that have done this, and I can tell you that my colleagues from coast to coast and border to border have condemned this whole process of lawyers getting on television and talking about cases that they don't know a damn thing about and don't have the experience to back up their words or the law to do it. Now you've learned a lesson.
Well, Susanna, that's rather righteous of him, and I understand. I can only imagine what he would have said if his client had been convicted. But the stories that they were throwing in front of that jury about the grandfather, it seems like you're an expert on defense attorneys. They'll basically do what it takes to get their client off, won't they? Including developing rather absurd, even narratives.
That's right. I mean,
sorry. Go ahead, Susan. I'm sorry.
To me, I would say pot, kettle, black. Yeah, the prosecution has a job, which is to search for the truth in the courtroom and to seek justice. The defense's job is to get their client off at any cost, short of crossing an ethical line. Savannah, sorry.
No, I'm sorry, Savannah. But coming up with the idea that the grandfather somehow was involved in this cover-up to the point of making him look like the real, if not the villain here, something close to it, that seems to be what defense attorneys are capable of to win a case, and they succeeded.
Well, yes, although because we haven't heard from the jurors, we don't know if this ultimately was persuasive to the jurors. It may be at the end of the day that the jurors ultimately just thought the prosecutors failed to meet their burden of proof, and they may have rejected the defense theories just as much as they rejected the prosecution theories. Until we talk to the jurors, we really don't know. I thought the prosecutors did a pretty good job of debunking the defense theories and saying why they didn't add up, why it didn't make any sense. And frankly, this defense lawyer was criticized a lot by those pundits out there who shall remain nameless, that there was no need for the defense to tell this elaborate story of George Anthony and the cover-up and the sexual allegations, because frankly, just picking at the prosecution's evidence and pointing out the weaknesses and the flaws in the prosecution's evidence was sufficient to give jurors a reasonable doubt about these charges. Until we hear from the jurors, though, we don't know whether they bought the defense theory or whether they just rejected the prosecution's evidence.
What I thought was
I'm sure the defense attorneys look upon it as the ends justify the means. They got their person off, and we'll probably have that mystery for a while. Anyway, my dad was right. You can't predict a jury. And that was after 30 years of experience. Thank you very much. Great having you on, Susan Filan. And thank you, Savannah Gus.